Live. Okay, we're live right now, brother. Okay.
Go ahead.
Okay. Today, folks, our guest is James Tench from Chillicothe Correctional, and today we're going to discuss a little bit about his case. He says he's innocent, and I believe it. So let's let him share a little bit. Go ahead, James.
Okay. So I did a little interview about a month ago and had a hard time getting a follow-up done. So I'm basically going to give a background on the case. If anybody has any questions, feel free to just go ahead and ask. November 12th, 2013, my mom was discovered murdered, and ultimately...
This call is originating from an Ohio correctional facility and may be recorded and monitored.
Ultimately, Medina County and Burlington Police Department decided that I was a suspect because I had prior bad acts, which included an aggravated robbery, which I did 6 years for. So because of that, they honed it on me instead of more likely suspects, which we have proof of the more likely suspects, but I'll discuss that later on. Basically, my conviction is because of prior bad acts. My entire trial was littered with things I've done wrong prior in my life. Hardly any of the information that came out at the trial contained anything that says I am guilty of this crime. In the direct appeal process, which is basically everything that came out at trial, no new evidence, nothing that didn't come up or anything like that. It's just everything that's on the court record. In my direct appeal, which is the first appeal that you get after being convicted, goes to the Ohio Supreme Court directly. The Ohio Supreme Court came back and said first of all, they dismissed some of my charges because they were invalid charges and had no basis, even though I was convicted on those charges. And then secondly, they said all the prior bad acts was improper. Everything that came up in my trial was improper. But according to the Ohio Supreme Court, because of overwhelming evidence of guilt, even though all this bad act stuff was improper and shit never came up and had an impact on my trial because of the overwhelming evidence of my guilt, supposedly, all that stuff was harmless. The Ohio Supreme Court states the following as overwhelming evidence of my guilt. There were a pair of brown hiking boots that were found at my mom's house. The Redwood Burlington Police Department, the detectives, said that they saw me put these boots on in front of them while I was barefoot. And I walked around the yard and the property and showed them the house while wearing these boots while I was barefoot. Well, the boots came back as having some of my mom's blood on the outside of the boots. Now, I testified at trial, and I said over and over again that these boots were not mine. The DNA test come back, and they swabbed the inside of the boots, including the inside of the tongue, inside of the hole, everything else. DNA results come back that I am not a contributor, which means I did not wear those boots. But because this information did not come up at trial, it was not presented to the Ohio Supreme Court as part of the record.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
At trial, I testified that these boots belonged to my dad. My dad was, pardon my French, he was a piece of shit. drug abuses, alcoholic, and I spent a lot of my time growing up defending and protecting my mom and my younger sister from him when he would go on religious. I testified at trial that after my dad passed away in April of 2012, my mom would slip these boots on to just go first thing in the morning to get the newspaper or the mail or whatever. And in February before she was killed, so about 10 months before she was killed, she put the boots on to go get the newspaper in the morning and slipped and fell in the driveway. And busted her nose up pretty good. That is the only reasonable conclusion I can have for that blood being on those boots. I testified to this, that my mom did fall in the driveway at this time. And the prosecutor called me a liar because why would some lady wear a boot that's too big for her to wear? Well, in a police report that the Brunswick Police Department had from one of their officers on November 27th, 2013, it states that my younger sister told them that my mom slipped and fell in the garage because she was wearing shoes that were too big for her feet and busted her nose pretty bad. It caused my mom to have periodic nosebleeds down the line because for some reason it never healed properly, or dry air, I don't know. But there was never, I knew it never, like, I've never having any medical reason for her to have bloody noses. I do know she discussed it with my aunt, Rebecca Harrison, on a couple of occasions, in a signed affidavit that me and my attorneys now have. She says that my mom discussed the nosebleeds with her on multiple occasions.
Why don't you let our friends know what your sentence exactly is before we run out of time?
Okay. Well, my sentence is I'm sentenced to death. I was convicted, and the jury recommended the death sentence, and the judge carried it out. Right now, I do not have any kind of execution date or anything. But the hard time I'm having right now is I've had motions and a post-conviction appeal, which is all this new information, in front of Judge Kimbler in Medina County for over 2.5 years. And she has refused to rule on anything. Basically, the judges have there's no law or no rule or anything that says they have to rule on anything in any amount of time. They can take as long as they want. There's been guys that have waited over 10 years to get a ruling on a post-conviction appeal from the trial court.
Wow.
So that is where I'm at right now. Judge Kimball is refusing to rule because of how bad she botched my trial.
Yeah.
Let me explain this. I have an affidavit from a juror that said on my trial. And she says she was literally bullied by some of the other members of the jury to change her verdict to guilty and to the death penalty. She also states that there was a lady on the jury that works for the prosecution's office that says to tell all the other jurors that she knows what she's doing, everybody should believe what she says, and I quote from the juror that came forward for us. She said, the juror that says she works for the prosecution's office said it's not like putting a puzzle together. All the pieces don't have to fit. He's guilty. Believe me. End quote. So, all the jurors decided to go along with her. We have an alternative suspect that I was not allowed to put on the stand. I was not allowed to question. I was not allowed to do anything with. This is my younger sister and my brother-in-law, Jennifer and Matthew Swain. My sister has, sister's mom. She's 3 years younger than me. Now, last I knew, she had 6 kids. She lives in Montville Township in a home she cannot afford. She's in bankruptcy and foreclosure, and she has the money motive to do this. Also, she has a history of violent behavior. I have a signed affidavit from my cousin Megan, who is about 2 years old.
This call is originating from an Ohio correctional facility and may be recorded and monitored.
This is going to make some people uncomfortable, but she says in the signed affidavit that my sister basically raped her when she spent the night one night at her house. Also, she says how my sister repeatedly beat her in the head and pushed her against the wall and beat her in the head over and over again because she told my parents that my sister was having sex with a carnival worker at Brunswick Old Fashion Days when my sister was 15. As you can see, my sister has plenty of prior histories of violence and just deviant behavior. There's also signed affidavits from my mom's best friend, Cheryl Turner, who I hope you will speak to at some point in time. She said she was going to call in and do an interview. She said she told Brunswick Police Department and also the prosecutor, Dean Holman, over and over again that they should be looking at Jennifer, not me. I have a signed affidavit of my Uncle Greg. Same exact thing. My defense lawyer had all this information regarding my sister and refused to investigate her, insist she was going to go on a stand or anything. So I was not allowed to even carry out my own defense. That is a huge issue of ineffective assistance of counsel because as a defendant, you have the right to defend yourself by any means within the courtroom that's necessary. And you would think that all this other stuff that was put on about, my robbery and all this other stuff I've done wrong in my entire life would take the back seat to the victim's own daughter. The person closest to the victim and your suspect, you would think you would want to testify. But I was refused and not allowed to put her on the stand because the prosecution knew that if she gets on the stand, she's going to blow up their case. I have, to make matters worse, about 3 days after my mom was killed, there was a police report from Brunswick Police Department concerning my sister. It's from the veterinarian, my mom's 13-year-old Cocker Spaniel. She basically called Brunswick Police Department to say some strange behaviors happening with the victim's daughter, Jennifer. She dropped off her mother's Cocker Spaniel, and it was dead. But there was no apparent injury or anything. Turns out the dog was poisoned. So my sister poisoned my mom's dog. And while she was at the vet clinic, there's statements.
You have 1 minute remaining.
And can you call back, or should we make it another day?
I can call back in 30 minutes.
Okay, let's do it another day then. Okay.
Okay, what day you want to do?
Let's see. Let's do it tomorrow, same time.
Okay. And if anybody has any questions between now and then, just have them send them to you, and you can ask me live.
Sounds great, brother. Okay, thank you.
This call is originating from...
That is James Tench from Death Row. He was convicted out of Medina County, and I know 3 other people that claim innocence out of there from Judge Kimbler, Mr. Kimbler at the time, and then all they did was switch positions with his wife, and she became the judge out there. I would like you to stay tuned for tomorrow for part 2. If these guys are innocent, which I believe they are, and other people are wrongfully convicted, that what that means is they were guilty of something, just not what they were convicted of, because the courts like to over indict. We need assistance to help these folks. If there's any attorneys, news you're watching, please help these folks so that they can get a fair opportunity for their release. Thank you, everybody. Have yourself a great, great day.